She served me divorce papers on a Tuesday morning like she was handing me a grocery receipt. Smiled like she'd already won everything. Told me I'd never see my son again. What she didn't know, I'd been quietly building a case that was about to burn her entire plan to the ground, that I'm 34. Project manager at a mid-sized construction firm in Columbus, Ohio. I coach my son's soccer team on Saturday mornings. I meal prep on Sundays. I'm the kind of guy who fixes problems quietly and moves on without making scenes about it. That's the version of me my wife knew, which is probably why she thought this was going to be easy. We'd been married 6 years when she handed me those papers. Our son had just turned 5, and if I'm being honest, the marriage had been deteriorating for 2 of those 6 years. But I've been calling it going through a rough patch, the way you call a flooded basement a little moisture. Looking back, the signs were always there. She kept a separate savings account even after we bought the house together. She had this way of reframing arguments until the original issue dissolved, and somehow I was apologizing for something I hadn't done. I'd accepted those things as quirks. They weren't quirks. They were a skill set she was developing for a specific purpose. The Tuesday she filed, she was already dressed and showered by 7 in the morning. I was still in the kitchen pouring coffee when she placed an envelope on the counter and walked back toward the living room without a word. "What's this?" I asked, picking it up. "What it looks like," she said, scrolling her phone. I opened it. Divorce petition. Filed 3 days prior. She'd been at the courthouse while I was running a work meeting and picking our son up from daycare. "You already filed?" Without saying a single word to me. "There's nothing to say. We have a son." "I know we do," she said. "That's why I filed." She picked up her keys and walked out. The door clicked shut behind her. I stood in the kitchen in yesterday's socks, holding divorce papers while my son slept upstairs, completely unaware that his life was about to be restructured by someone who had been planning this for months. Her petition was detailed and thorough. Primary physical custody, child support, spousal support. She cited irreconcilable differences and described me as emotionally unavailable and disengaged from family responsibilities. That last part almost made me laugh. I was the one who showed up to every pediatrician appointment, every school function, every soccer game in the rain. But I didn't laugh. I called a family law attorney. My attorney had been practicing family law in Ohio for over 20 years. He met with me the following morning, reviewed everything, and laid it out plainly. "Does she have documented evidence of abuse, neglect, or substance issues?" he asked. "No, because none of that exists." "Then this is a standard contested custody case. Ohio courts strongly favor shared parenting arrangements unless there's compelling cause to deviate. You have a real shot, but you need to be disciplined." "What does that mean practically?" "Document everything, every interaction, every conversation with your son, every text, every exchange, date, time, exact words. Start today." That instruction became my entire personality for the next 9 months. I also want to mention something my wife said to me the night before she filed, something I didn't understand until much later. We were in the kitchen, and I'd made a comment about a coworker who'd been caught lying to management. She looked at me for a moment and said, "People always show you who they really are eventually." I nodded and kept washing the dishes. She wasn't talking about my coworker. The first few weeks, we were still living under the same roof. She moved through the house like I was furniture. I made breakfast for our son every morning, packed his bag, walked him to the car. She'd take the keys without acknowledgement and drive him to daycare. One morning, my son looked up at me from his cereal bowl and said, "Daddy, are you sad?" "No, buddy, just tired." He was quiet for a second, then said, Mommy said you make people feel sad. I kept my face completely still. I kissed the top of his head. I poured my coffee down the drain because I'd lost my appetite entirely. Then I went to my room and opened my documentation log. Date, time, exact words, context. I didn't know it yet, but that entry was going to matter in a courtroom. Copy Section 2. My attorney filed our response, requesting joint physical custody, rejecting the spousal support claim outright, and countering her proposed asset division. Her attorney fired back within a week. Their response was layered and structured and way too ready for something that should have been a first exchange. That's when I understood. She hadn't just decided to leave. She'd been preparing for this for a long time. Dirty trick number 1 landed 3 weeks after filing. My attorney called me on a Thursday afternoon. I was on a job site and stepped away from the crew to answer. She filed an emergency motion, he said, alleging domestic violence. She's requesting a temporary protective order and immediate sole custody pending the hearing. Everything around me went quiet. That never happened. I know. But the court is required to take these motions seriously until they can be properly contested. Temporary orders can be issued ex parte, meaning without your presence or input. So she makes an allegation in a legal filing and they hand her my son? Temporarily, until we contest it at the scheduled hearing. Yes, the protective order was granted within 48 hours. My access to my son was restricted to supervised visitation, twice a week, 2 hours each session at a county visitation center. I sat across a plastic table from my 5-year-old while a caseworker took notes in the corner like we were a research study. My son kept asking if we could go to the park. Soon, buddy. You always say soon, Daddy. I know. I'm working on making it happen. Her claim was that I had physically shoved her during an argument 6 months prior. No police report, no medical records, no photos, no witnesses, nothing but her signature on a legal document. Here's the thing about filing a false emergency motion in family court. It works in the short term precisely because courts are designed to take these claims seriously. She understood that. This wasn't a desperate move. It was a calculated opening. We went to work dismantling it. I'd installed a home security system 2 years earlier after a car was broken into on our block. Cameras covering the living room, the front hallway, and the entryway. I pulled every clip from the 6-month window she had cited in her motion. Nothing. 2 people clearly living in a Cold War, but no physical confrontation, no incident, nothing that matched her description. We submitted the footage. We pulled 3 years of text message records. We obtained written statements from 2 neighbors who had regular contact with our family and had never seen or heard anything concerning. The protective order hearing was scheduled for 6 weeks out. She escalated before we could get there. Dirty trick number 2. I was called in my boss's office on a Wednesday afternoon. He's a no-nonsense guy who has managed construction crews for 2 decades. Seeing him uncomfortable was unsettling. I got an anonymous call this morning, he said, studying his desk. Caller said you had a domestic violence charge pending and that I should be aware of it. I kept my voice level. There's a temporary protective order based on an uncontested allegation. No arrest, no charge, no conviction. I'm actively contesting it in court. You should have told me. It was issued 14 days ago. I didn't anticipate it reaching my workplace. He put me on 2 weeks of unpaid leave. Just until this clarifies, he said. He looked like he felt bad about it. That didn't help. 2 weeks of no income. Right before a custody evaluation designed to assess my financial stability as a parent. The timing was not a coincidence. My attorney subpoenaed my employer's call records. The call had come from prepaid number. We couldn't directly attribute it to her, not yet. But the timeline and the strategic impact were documented and preserved for court. She's running a full campaign against you, my attorney said. I noticed. It means she's worried. People who are genuinely confident don't scramble this hard. That was, oddly, the most encouraging thing he'd said to me in 2 months. Dark humor has a way of showing up when you need it. At this point, I was 2 months into losing custody of my son and had just been put on unpaid leave, and somehow my attorney's version of reassurance was the thing keeping me functional. Outstanding situation overall. The court-appointed custody evaluator entered the case about 4 months in. In contested custody proceedings in Ohio, the court can assign an independent evaluator to interview both parents, observe parent-child interactions, and submit a formal recommendation to the judge. This person carries enormous weight in the outcome. Both attorneys knew it. Both parties knew it. My wife knew it most of all. I started noticing changes in my son during our supervised visits. Small at first. He'd use phrases that didn't sound like him. Structured, formal, delivered in a small, careful voice. Daddy, you're not always home when you're supposed to be. Daddy, you get really frustrated sometimes, and it scares people. Those sentences don't come from a 5-year-old unprompted. Those are prompts fed to a child who trusts the adult feeding them. I didn't react visibly. I kept engaging him the same way I always had. Asked about his dinosaurs, what he had for lunch, whether Gerald had gone on any new adventures. Gerald the dinosaur had by this point survived a volcano, 2 ocean crossings, and a brief stint as a submarine captain. The kid has genuine narrative range. But every scripted phrase my son delivered, I wrote down afterward. Date, time, exact words. My documentation log was approaching a length that would embarrass most published authors. Then came dirty trick number 3, and this one was the worst of all. The custody evaluator contacted my attorney after her first home visit with my wife. She had a disclosure she was required to flag. My son had described, apparently spontaneously, an incident in which Daddy threw the remote at the wall and made a hole. I knew that hole. I had knocked a framed picture off the wall while rearranging furniture in the living room 18 months prior. The corner of the frame punched through the drywall. My wife had been standing right there. She watched me patch it the following weekend and never said a word about it. She had taken that memory, reframed it as a violent outburst, and taught it to our son as a story he believed he remembered on his own. I sat with that for a while. The specific calculation of it. Using your child's trust, his desire to be helpful, his inability to distinguish between a memory and a script that required something beyond anger to process. It clarified something, though. I was done being measured and patient about this. She had used my son as a weapon. So now I was going to be thorough in a way that she had not anticipated. I called my attorney that night. She coached him. I said, "Can you prove it? I'm going to build a case for it." Same methodology she used to build one against me. We hired an independent child psychologist specializing in forensic child interviews and parental alienation cases. 3 sessions with my son using structured techniques. No leading questions, no prompts. Just careful, methodical listening. Simultaneously, I started looking harder at my wife's financial claims. She had filed for spousal support alleging financial hardship, claimed she'd been out of work for over a year, surviving on savings. But 4 months before she filed for divorce, she had purchased a new car outright. She had taken a trip to Florida in January and posted photos. She had gone to a resort in Tennessee in March with friends and documented the entire trip on social media. I hired a forensic accountant, not because I enjoyed spending money I didn't have, At this point, the litigation costs were becoming their own form of entertainment, in the way that watching your house burn down is technically a light show. The accountant pulled public business records and found something interesting. My wife had incorporated a freelance consulting LLC 2 years earlier, registered under her maiden name. She had been invoicing clients and receiving payments through a separate business account. Approximately $38,000 in income the prior year. None of it appeared anywhere in her financial affidavit to the court. She had declared zero income to a judge while operating an active business. "We sit on this," my attorney said. "We let it fully develop, and we walk into that final hearing with everything at once. Don't tip her off." "How long?" 6 weeks. Then we go. I want to say the waiting was the hardest part, but it wasn't. The hardest part was the end of every supervised visit, saying goodbye to my son at the door of a county facility and walking to my car alone. But I was going into that courtroom with everything she hadn't counted on, and she had no idea what was coming. The final hearing was on a Friday morning in March, 9 months after she placed that envelope on the kitchen counter. I walked into the courtroom in a suit I'd pressed myself the night before, carrying a folder 2 inches thick, and I felt something I hadn't felt since this started. Still. Not calm, still. Like water right before it starts moving very fast. My attorney entered the home security footage first. The footage covered the living room and hallway across the full 6-month window she'd cited in her emergency motion. It showed 2 people who had clearly stopped speaking to each other in any meaningful way. It did not show a shove. It did not show a confrontation. It showed nothing matching her documented allegation. The footage is not conclusive of the claimant's subjective experience, her attorney argued. It is, however, conclusive of the absence of the specific physical incident described in the filing. The judge replied, "Motion to sustain the protective order is denied." My wife's expression didn't change. She was practiced at that. Then the independent psychologist took the stand and delivered her report. The findings identified language patterns in my son's statements that were inconsistent with how children his age spontaneously recall and report events. The specificity of phrasing, the adult-adjacent sentence structure, and what she described as emotional flatness during delivery, presenting a frightening story without the natural emotional texture a child would attach to a real memory, were consistent with Coach disclosure. Her attorney came at her hard. Isn't it possible the child simply recalled the event accurately and described what he remembered? It is possible, she said. It is not consistent with the forensic markers present. Children recalling emotionally significant events attach personal emotional language to those memories. This child presented the narrative with the structure and effective detachment of a repeated recitation. That pattern is what I observe in Coach disclosures. That is my professional opinion. The room was completely quiet after that. Then the forensic accountant submitted his report. My wife had declared zero income on her financial affidavit. The report documented an active LLC, 2 years of continuous business activity, and $38,000 in income in the prior tax year. None of it disclosed to the court. Her attorney requested a recess. The judge gave 10 minutes. I watched my wife lean toward her attorney at their table and speak in a low, flat voice. Whatever she was saying, it wasn't a confident conversation. It looked like someone doing rapid recalculations on a plan that had just stopped working. Dark humor has a way of arriving right on time. She'd spent 9 months trying to construct a version of me that was unstable, dangerous, and unfit. Meanwhile, the thing that actually unraveled her was an LLC registered in her maiden name and a public Instagram account. I didn't enjoy that. Okay, I enjoyed it a little. When the hearing resumed, the judge was direct. The court finds the respondent's financial disclosures to be materially incomplete and inconsistent with documented business records. The court further finds that the independent psychological assessment raises significant concerns regarding the respondent's conduct toward the minor child. Both findings weigh heavily in this determination. Primary physical custody was awarded to me. My wife received parenting time every other weekend and one weekday evening. The spousal support request was denied in full. The court referred the financial affidavit discrepancy to the county prosecutor's office for review. She was investigated. She ultimately accepted a plea. One count of perjury reduced to a misdemeanor in exchange for full financial disclosure and payment of court-ordered costs totaling $4,200. Everything for me. It wasn't a life-altering sum, but having to sign your name on a check made out to a court of law because you lied and got caught and couldn't talk your way out of it, that hits different than any number. My son is 6 now. Gerald the dinosaur has semi-retired to a shelf, but comes down for special occasions. Last Saturday, my son fell asleep on my couch with a half-empty bag of dinosaur crackers resting on his chest and a cartoon playing to no one. I sat there for a while and just watched him breathe. That's 9 months of fighting laid out in one quiet Saturday evening. She handed me papers on a Tuesday, like I was already finished. She didn't count on the security footage, the forensic accountant, or the simple fact that I wrote everything down. She gave me papers. I built a case. If this story had you white-knuckling your phone, hit subscribe, because unlike a certain someone's financial affidavit, we don't leave anything out around here.